During the presentation, you can actually answer questions and join. So if you get your smartphone and you can download the app, just go to Poll Everywhere. Or it's on the App Store. You just go to the App Store or the Play Store. And it's a free app. So just go to the App Store and the Play Store. And it's you can do it on your Android and if you want to use a web, you can. If you just have your and you don't have an app and you want to use your computer, you can go to the website. You can download. It's a free app, and then we can join. You can join the polling, and we'll do some live polling with the audience as we go on. I'm going to announce it again. I'll just it's easier for me to announce it than for him. I'll just subvert the chairs. Good morning. How are you? Good to see you again. Right. You've got to keep Midas on a strict time clock. Okay. He's only doing 15. I'm doing 25. And she's doing 25, and then he's doing 5. No, he was still at the other. Yeah, he was still at the other session. Thank you. Thanks. That's his problem is because he didn't come on time. He had to go vote over there. They're voting. You're not a voting member. So how come you was voting over there? Whoever cut the check. Well, it's a technology one. So the one thing is that I have a 7-minute video that is Judicial Academy that is part of my presentation. So that's why I'm taking 5 minutes from him. And I told him to make sure we've got to be passive for the 7 minutes while that video plays.
We're always talking
Weeks before. Yeah, but we had our session last night. Grace was hiding the whole time. We were searching for her. She was just out every night. We never could find her.
Laws on the states is on the territory, so I'm not sure what kind of representation.
Okay.
States
That's your colleagues and taking care of them. They want to send the pictures to your husband to show that you were really here.
He often goes in the he's already like this thing, yes, but it's all
Oh, hang on, they're going to give us an official photo.
I'll see you twice this year already. Yeah.
Special
Extend judge 100%.
Bus download Paul everywhere.
Yeah, I'm over. You gotta install that app. The name of the app is Poll Everywhere. Once it comes up, it's 40 will participate in this. Is that not all? Yeah. Just down, just search for the app. Poll Everywhere.
This is official.
I know. I mean, it's 32.
You want to join
If you're just coming in now, you can go to the Play Store on your Android or the App Store, or go to your computer if you don't have a smartphone, and you can download or go to this website and download the app, and you can join. Just type in Guam Justice, and I'm joining a presentation, and put Guam Justice on it, and then I hope to do some interactive polling with the audience, during my portion of the presentation.
on the stage, you feel you let me know. And then you have to go back here.
You were there because he's only got 7 minutes, so you don't introduce him in the double day. No, you just say skip. Because it's free. Yeah, Midas will give you his credit. That's what she was hoping when she came up. I said, skip. Yeah, and then open it. Just click open.
Some of my relatives were visiting there. It's the prettiest place. Because you'll sit in some flat, like a less than 1 hour room or something. In San Francisco, you need to walk across the
And you'll see it when the questions come up, then you can
building all the cities all kind of built up around.
Yeah, it's okay.
You're right there in the Pacific Ocean. It's the first city that will be visiting next time.
You're ready to join. So once I put a question up, you'll see it.
Graduate
You
school.
can answer the question right on your smartphone.
I've had it twice.
Okay. How are you? Pleasure to meet you. Alright, perfect. Now you can answer the questions, the polling questions. Yeah, you can call it. Yeah. You get into trouble, it's yes or no, so I mean, and there's no right answer. I mean, it's clipper. Well, it doesn't matter because I don't have any time. No, because I can go because I go second. Midas and I care for the single down to the
Now, thank you, ladies and gentlemen, and welcome to the next session. I'm your chairperson for this session on the use of technology by judicial trainers. It's an area I've got great interest in, and I was so pleased to be given the opportunity to chair it. This is one of 3 concurrent sessions for this morning under the theme Training Methods and Goals, and we have 4 speakers with us, and in this session we will discuss the benefits of using online and e-learning platforms by various judicial institutes. We will now proceed to I'm conscious that we've got a lot of ground to cover in a short time, but you may be sick of hearing this announcement, but I've been asked to remind you of some of the house rules. Okay, and for security reasons, make sure you wear your tag. Please switch off your phones and make sure they don't start ringing. So that we can adhere to our program schedule, we will do away with the introduction of the lecturers. Profiles for the lecturers you'll find in the program. And our speakers are requested to strictly observe their time allotments. For this section, the speakers will be given 20 minutes. The lady down here is going to put up a cue card and keep the speakers in line. And should time permit, and I hope it does, at the end of the 4 presentations, we should have about 10 minutes left for an open forum or the opportunity to ask the presenters any questions. You also will find in your conference kit question slips, so if you want to put your questions in writing, please do so, and the questions will be answered. Now, may I now call on the Honourable Jose Midas Marquez, I hope I got that right, who is the Chair of Philja's Department of Court Management and Court Administrator of the Supreme Court of the Philippines, and he's going to deliver his presentation on creating the Philja online training hub. And I was most impressed by Philja Academy yesterday, so I can expect something really good this morning. Thank you.
Thank you, Ernest. Good morning, everyone, and welcome to the 3rd day of our 8th International Conference on the Training of the Judiciary with the theme Judicial Education 2025, Core Values and Future Innovations. This is session 13 on the use of technology by judicial trainers, and my assignment this morning is creating the Philippine Judicial Academy's online training hub. Allow me please to start with a brief overview of the Philippine Judicial Academy, especially for those who were not able to attend session 3 last Monday, where our Chancellor, retired Supreme Court Justice Adolfo S. Ascuna, delivered a presentation on the Philippine Judicial Academy, or PhilJA. The PhilJA was first established by the Supreme Court in 1996 as an administrative support office and later strengthened and institutionalized with the enactment of a law in 1998. Thus, in 1996, the Supreme Court issued an administrative circular establishing the Philippine Judicial Academy, which shall be charged with the formulation and implementation of a continuing program of judicial education for justices, judges, court personnel, and lawyers. Then, in 1998, Republic Act number 8557, otherwise known as an act establishing the Philippine Judicial Academy, defining its powers and functions, appropriating funds therefore and for other purposes, was enacted. The PhilJA shall be a separate component unit of the Supreme Court and shall operate under its administration, supervision, and control. Section 3 of Republic Act 8557 provides that the PhilJA shall serve as a training school for justices, judges, court personnel, lawyers, and aspirants to judicial posts. Eventually, the PhilJA was fully organized. It is governed by the Board of Trustees with the Chief Justice of the Supreme Court as the ex-officio chairman and the Senior Associate Justice of the Supreme Court as the ex-officio vice chairman. The court administrator sits as one of the ex officio members. It is run by its executive officials composed of a chancellor, vice chancellor, and an executive secretary. As mentioned by Chancellor Oscuna in his presentation last Monday, the PhilJA also finds success because of the mandated built-in support of the Chief Justice and the Senior Associate Justice of the Supreme Court as heads of its Board of Trustees. It has 6 offices: the Administrative Office, which oversees the implementation of the functions of its Corporate Planning Division, Administrative Division, and Information Systems Division. The Finance Office, which formulates, allocates, and administers the Academy's budget and funding sources. The Academic Affairs Office, or AAO, which drafts the curricula and plans the academic undertakings of the Academy. The Research, Publication, and Linkages Office, RPLO, which is responsible for the plans and policies for the effective implementation of research and development activities. The Philippine Mediation Center Office, which is responsible for the development, implementation, and monitoring of judiciary-led ADR mechanisms. And the PhilJA Training Center Office, which administers the affairs of the training center we went to yesterday in Tagaytay. Noticeably, there is no office that handles e-learning yet. The courses PhilJA has developed can be divided into 5 different programs: core programs, convention seminars, special focus programs, special lectures, and ADR and mediation lectures. In 2016 alone, the PhilJA conducted 22 core programs, coordinated 10 convention seminars, organized 73 special focus programs, convened 2 special lectures, and handled 20 ADR and mediation lectures. These courses and programs primarily cater to the justices, judges, and court personnel, including court lawyers and aspirants to the judiciary. In 1996, when PhilJA was first established, we only had some 2,130 judicial positions in the first and second level courts, and more than 24,000 positions for court personnel. 2 decades later, at present, we already have more than 2,600 judicial positions and more than 30,000 positions for court personnel. I say positions because we have varying vacancies at any given time due to retirements, resignations, and other modes of separation from the service before we can fill in these positions. Many, if not all, of our judges look forward to the trainings and seminars of the PhilJA. More so are court personnel who avail of these trainings because these are requirements for promotion. A clerk of court of the regional trial court, for instance, would need 16 hours of relevant training. A records officer 5 of the regional trial court would need 24 hours of relevant training. A social welfare officer 3 of the RTC would need 8 hours of relevant training, while a court stenographer 2 of the Metropolitan Trial Court would need 4 hours of relevant training. With these training needs of our growing judicial workforce spread nationwide over more than 7,600 islands, which are likewise increasing. That is true because some 2 decades ago, we only had 7,100 islands. It would simply be impossible for all our judges and court personnel to undergo or participate even in just 1 course in a given year, not to mention those who simply want to access different lectures for their personal advancement or even mere curiosity. Hence, the need to develop another system that can run parallel to our existing system and be more responsive to the needs of our justices, judges, and court personnel. Online education programs are nothing new. These have been in use in other jurisdictions. For instance, to name a few, the Judicial Institute for Scotland has a judicial hub designed and developed to provide fully integrated one-stop virtual learning and communications platform. The online learning module at the National Judicial College at the University of Nevada allows participants to study at any time and interact with many judges from around the country in a collegial online atmosphere. The online programs of the National Judicial Institute in Canada use a web-based course site to facilitate discussion and collaborative learning designed to complement in-person learning. There are several online education sites one will find in the internet. The PhilJA should thus not be far behind. In fact, in 2009, the Philippine Supreme Court already approved the Enterprise Information System Plan, or EISP, which provides for the Philippine judiciary with functional, technical, and instructional specifications for the development of its ICT capability. Included here is the ePhilJA system, which covers online tutorials. Hence, what is being proposed is the eventual creation of the PhilJA Online Training Hub that will house all its online courses and programs. Online programs offer a number of advantages: enhanced access, lower costs, greater chances of participation unhindered by time, distance, and location. Programs can bring together judges from across the country and even internationally and promote the sharing of a wide range of ideas and materials, and users can choose from a broad range of learning resources and can concentrate on topics of particular interest at any time. It is being proposed that the PhilJA Online Training Hub use a web-based course site that may easily be accessible by desktops, laptops, tablets, cellular phones, and other mobile gadgets. Initially, it is being suggested that the current lectures and programs of the PhilJA be converted into online lectures. Eventually, similar to the courses in the National Judicial Institute in Canada, PhilJA's online programs can be categorized between instructor-led or synchronous, where everyone will be online at the same time and discussing with the professor and other registrants, and self-directed or asynchronous, where the user can come online at any time and just post comments to what is called a judicial lounge for discussion. The courses can also be certificate courses or non-certificate courses. Certificate courses are for those who need to be credited for promotion or other purposes, where they will have to pass some tests or comply with some requirements online, for which they will thereafter be certified by the PhilJA as having taken or passed the course or training. They will have to turn on their webcams so the PhilJA can record their faces throughout the online program and be sure that the individual who accessed and registered for the course is really that same individual. The non-certificate courses are for those who merely wish to refresh or update themselves without going through the certification process. The online lectures or presentations can also be downloaded in a USB or printed with PhilJA watermarks. They should also be created in such a way that they can easily be updated for changes in the law and jurisprudence. The formats of the online courses can vary to make them more interesting and engaging, from the simple audio-video conferencing to the interactive animated videos and presentation. Camtasia, Powtoon, GoAnimate, Adobe Presenter, Zentation are just some of the video presentation tools that are easily available in the market. I'm therefore excited to listen to the presentations of Chief Justice Robert Torres of Guam on the use of online platforms and interactive avatars, of Ms. Lu Xiaoyun of Taiwan on the e-lecturing system of the Academy for the Judiciary of Taiwan, and of course, our Judicial Commissioner Dean Fu Chi Hock, which of Singapore on gamification, which I am sure can all be incorporated in the training modules of the PhilJA Online Training Hub. Eventually, the creation of an in-house production unit in the PhilJA for the administration of the online courses is being proposed, which will be composed of a pool of judicial educators who will conceptualize and visualize the online programs, and a staff of programmers, visual artists, and animators to implement and create the different online courses. In the meantime, some online programs can already be developed by linking with the schools and students of multimedia arts, communication arts, graphic design, animation, and others. Perhaps the court's development partners can also come in and help in the initial creation of these online courses. In ending, it is hoped that the PhilJet can start developing its online programs very soon to keep it abreast with the best judicial training institutes in the world and in its pursuit of excellence in the judiciary in the 21st century. Thank you.
Thank you very much for that very informative presentation. Our next presenter is someone who I've known for a number of years. On another board that I sat on some time ago. And it's the Honourable Justice Robert J. Torres. Justice Torres is a judge of the Supreme Court of Guam, and he's also on the Guam Judicial Centre. I think you'll find this presentation not only informative but entertaining. Thank you.
Good morning, everyone. It's a pleasure to be here in the Philippines. Always enjoy coming here. We're going to. I mentioned to a number of you that were coming in earlier. If you haven't done so already, I'm asking you to go ahead and, if you have a smartphone, download from the App Store or from the Play Store, Pull Me Everywhere software, and you can join my presentation, Guam Justice, and we'll actually do some interactive polling with the audience and see about some of your reactions to some of the programs that we're going to be doing. Midas talked about, Cordad, about some of the stuff that the Philippine Judicial Academy is developing. And I'll actually run a 7-minute video of one of their model code of judicial conduct training online courses, just a rudimentary version of it. And I know it's kind of a long video, 7 minutes, but there are a number of Filipino judges who are in the audience here. And after many nights of San Mig with Midas, we agreed that it would count for your ethics course for this year by watching that 7-minute video. So it should be fine. And he said he would issue the circular later in the year concerning that. So we're going to talk about, and what some of our learning objectives are here today, is looking about virtual worlds and the avatars as a method of really facilitating judicial learning and looking at ways that we can create virtual learning environments. Now, we know that judges in the trial courts are the foundation of the judicial system in countries throughout the world. They're really the ones in the trenches, and they're in the front lines of the legal battlefield, so to speak. And they have diverse caseloads that range from contracts to murders, family cases, and oftentimes they're the first parties that the public interacts with in the judicial system. And so the reputation of the judiciary is mirrored on what they do each and every day. And so the quality of their work and the character of the judges themselves, I think, reflect the credibility and the integrity of the judicial branch. And so the litigants and the general community have an expectation of these judges, and it's important, therefore, that they adhere to the proper judicial conduct in all facets of their life. So training sessions and conferences which likely discuss the model code of judicial conduct often form the primary basis of ongoing judicial education. And so what do your training sessions look like? How is material presented at your conference? So in many of these instances, these seminars consist of a sage on a sage who's out there, or doing the typical classroom setting like we're having here. So let's just do, as a sample, a test on the polling just to see how it works, and if it is indeed working properly. It's more of a test that we'll try in there, and I'll activate the poll question, and let's go ahead and see. And have you attended these types of conferences before? We actually should have 100%, because everybody who's here has done it, but why doesn't someone put no as a sample? John Meeks, you can put no. And so we'll just, test the sampling of the Poll Everywhere software. And that's kind of just our test questions, so you know that it'll work. And we have some more questions that we hope we'll interact with a little bit later. But even as teaching methods now have become more interactive, and promoting audience participation through group discussion, role-playing, the polling that we're doing here, there's no real assurance that judges have absorbed the concepts that we're trying to put forward. And oftentimes these seminars, and Midas pointed out some of the downsides of engaging in these types of conferences and seminars, it takes you away from your courts. It leads to postponement of hearings and burdening of dockets, potentially the costs, a number of different factors. So, but beyond the classroom type setting is some of the blended learning that's occurring in a lot of jurisdictions. And that combines the traditional method with some distance education techniques. You know, you have recording of live lectures, they're doing that here now for future. You might have structured lessons with online quizzes, documents that can be viewed or downloaded on demand. But oftentimes these fall far short of capturing the full capability of what modern technological advances are holding for us. So one innovative and engaging alternative to traditional seminars and conferences that has been really underutilized in judicial training is the use of virtual environments and avatars. And I'll talk a little bit about some of the things that we can do with that today. So avatars are digital representations of the person who can move throughout the visual world, observing and interacting with other avatars and objects in the world. Of course, it's not the movie. And so let's do this other poll question. Have you ever had an experience in a virtual world? I'd like to see the number of responses we get and take a look at that. And let me just activate the poll question. Sorry, I got to switch screens here. I didn't embed it into the PowerPoint presentation. And then going in here, the poll question is activated. So have you had an experience in the virtual world? And some, it's basically roughly, more people have not, and then have. So it's interesting, we'll see. And so you can see that still, there's quite a few people who haven't had experiences in the virtual world. But really, will your answer change? Will your answer change if I asked you this question? Have you ever played one of these games or similar games? And it might. So we'll go back and take a look at that poll question real quickly. So here it was about 52-47 for those who have had a virtual world experience. And now we're going to go to the next question where I really showed you the games, because that is really part of the virtual world experience. And we'll see if now you see the differences, and when people look and really start to think about playing the games or doing the things that they've had, a lot bigger percentage of the audience is familiar with it in that concept. So I'm going to play the video now from the Philippine Judicial Academy. It's a 7-minute video, so you can take a little bit of a break, get some popcorn, while we can. Hopefully this will play very well.
Philja, e-learning module on the new code of judicial conduct. My name is Judge Robert, and I will be your guide in learning the new code of judicial conduct. The Philippine Supreme Court adopted the new Code of Judicial Conduct for the judiciary in its April 27, 2004 resolution.
I
in
noticed
the
it's
Initiative
new
Matter
even though it's
number
2004, so that's good
03-05-01-S,
hope for us who are
effective June 1,
aging that in a few
2004.
years will still be new.
It is based on the Bangalore draft of the Code of Judicial Conduct as amended during the roundtable meeting of Chief Justices held at the Peace Palace, The Hague in 2002. The Philippine Supreme Court was represented by Chief Justice Hilario G. Davida Jr. and then Associate Justice, later Chief Justice Renato S. Puno.
So PhilJA is developing some of
The
these
Bangalore draft is
tools and
intended to be
now.
the universal declaration of judicial standards applicable in all judiciaries. It is founded upon a universal recognition that a competent, independent, and impartial judiciary is essential if the courts are to fulfill their role in upholding constitutionalism and the rule of law, that public confidence in the judicial system and in the moral authority and integrity of the judiciary is of utmost importance in a modern democratic society, and that it is essential that judges, individually and collectively, respect and honor judicial office as a public trust and strive to enhance and maintain confidence in the judicial system. The Bangalore draft contains 6 core values which have been integrated in our new Code of Judicial Conduct. These are the values of independence, impartiality, integrity, propriety, equality, competence, and diligence. The new Code of Judicial Conduct supersedes the canons of judicial ethics and the Code of Judicial Conduct, but the latter may still apply in a suppletory character in the case of deficiency or absence of provisions in the new Code. Canon 1. Independence. A prerequisite to the rule of law and the fundamental guarantee of a fair trial, Canon 1 is subdivided into 6 sections. Section 1. Judges shall exercise judicial function independently on the basis of their assessment of the facts and in accordance with a consensus understanding of the law, free of any extraneous influence, inducement, pressure, threat, or interference, direct or indirect, from any quarter or for any reason. Section 2. In performing judicial duties, judges shall be independent from judicial colleagues in respect of decisions which the judge is obliged to make independently. Section 3. Judges shall refrain from influencing in any manner the outcome of litigation or dispute pending before another court or administrative agency. Section 4. Judges shall not allow family, social, or other relationships to influence judicial conduct or judgment. The prestige of judicial office shall not be used or lent to advance the private interests of others, nor convey or permit others to convey the impression that they are in a special position to influence the judge. Section 5. Judges shall not only be free from inappropriate connections with and influenced by the executive and legislative branches of government, but must also appear to be free therefrom to a reasonable observer.
And I'm sorry we're going to have to pay the whole
Section
video, but they
6.
don't qualify
Judges shall
for
be
their
independent in
CLE
relation to
credits
society in general and in relation to the particular parties to a dispute which he or she has to adjudicate. Section 7. Judges shall encourage and uphold safeguards for the discharge of judicial duties in order to maintain and enhance the institutional and operational independence of the judiciary. Section 8. Judges shall exhibit and promote high standards of judicial conduct in order to reinforce public confidence in the judiciary, which is fundamental to the maintenance of judicial independence.
And that's what we want you all to do after the
Canon
session.
2. Integrity. Integrity is essential not only to the proper discharge of the judicial office, but also to the personal demeanor of judges. Canon 2 is subdivided into 3 sections. Section 1. Judges shall ensure that not only is their conduct above reproach, but that it is perceived to be so in the view of a reasonable observer. Section 2. The behavior and conduct of judges must reaffirm the people's faith in the integrity of the judiciary. Justice must not merely be done, but must also be seen to be done. Section 3. Judges should take or initiate appropriate disciplinary measures against lawyers or court personnel for unprofessional conduct of which the judge may have become aware. Canon 3. Impartiality. Impartiality is essential to the proper discharge of the judicial office. It applies not only to the decision itself, but also to the process by which the decision is made. Canon 3 is subdivided into 6 sections. Section 1. Judges shall perform their judicial duties without PhilJA.
Mike says that he'll still give you credit even though we don't go through all of them. But they're actually going to be, there's some additional integration, fact scenarios that judges will have to respond to, and a live interaction. But really that blended world still, and it's a great step that Philja starting to do, but Philja has plans to even do more with that and work with the virtual world. And the virtual world exists wholly online, and it's been artfully described by one professor of law as an environment that allows students and faculty really from all over the world and different disciplines to interact and learn while sitting within the confines of their homes or classrooms. They're imaginative, dynamic, provocative, multicultural environments that can be explored, manipulated, reacted to, and developed in ways that are really limited only by the creativity of those that participate, a few basic community standards, and the evolving technical constraints which are starting to eviscerate more and more as technology advances. This type of learning, which is virtual learning or e-learning experience, immersive virtual world or multi-user virtual environment, are nomenclatures for that. And despite that futuristic sounding nomenclature, the concept of virtual learning really has existed since the 1920s. And that was when Edward Link designed and patented the Link Trainer, which was a virtual prototype airplane flight trainer. And he went on to not only have the first airplane specific flight trainer and simulator, but he also worked with NASA on their launch of the Gemini spacecraft. And so the potential for using virtual reality as a learning tool has been around for many, many years. And virtual learning environments have been now used for nurses, psychologists, and starting more and more in the legal realm and in some of the law schools. As I mentioned, the virtual world is a three-dimensional simulated environment where users interact in real time through an online platform or some digital space. The virtual environment can look just like the real world, and many simulators are doing that, or it can be completely computer generated. And to act in this virtual environment, users can create avatars which are online manifestations of themselves. Here's a sample of an avatar, and the user can use the avatar. It can be customized, it can be personalized, and he can use it in the virtual world and can engage in the interactions with others through text messaging, immersive audio, supported by a headset or by a microphone. Now, the virtual world, let's look at, this is an example of one with nursing where they actually can get in and being in the virtual world, simulate certain exercises and undergo certain training and be graded and evaluated on their responses on how they're doing it. Now, the virtual world can be created through a computer program where characters, as I said, interact with the learner's avatar in a series of learning modules. One of them is this program called Marvin Project. It's a storytelling program that uses animated characters to impart messages about services, businesses, and culture in various languages. And the avatar communicates to people using balloons or text-to-speech or speech balloons to communicate with the learner. And it guides him through the virtual environment, and that's some of the stuff that you're going to be seeing in the Philja modules that Midas was talking about. In those types of environment, in those virtual worlds, the modules are generally scripted in advance to fulfill those certain learning goals. In contrast, the online virtual world can more fully recreate life interactions. And one example is Second Life, which has been done by Harvard University and Linden Labs. And Harvard and Seton Hall are now using and have a virtual presence in Second Life. I encourage you, just go type in Google Second Life and start taking a look and seeing what's available in there. And in 2008, the State Bar of California approved legal credit for CLE for their lawyers through Second Life. The viability of Second Life as an educational tool has been explored in many academic fields, and one law school professor even offered a virtual online mediation course that they got a credit for. And what was interesting is that some of the students indicated that the opportunity for interacting through this avatar made the role-playing for them seem more real. And they took the exercises more seriously. And it also enabled students to sort of step outside of their traditional comfort zones and speak more freely without inhibition than they could in real life. And while academics who have used Second Life have acknowledged its potential, many have reserved judgment as to its efficacy. So there are a number of other alternatives for open source software that do virtual reality. So with regards to judicial training specifically, we talked about developing models that could be created with a computer program or online avatar. A judge, through the use of his avatar, could preside over the court hearings. He could rule on motions that occur from the lawyers. He could issue oral orders before avatars of attorneys and litigants. And as you practice and become more confident, they actually could behave more like actual human listeners, especially with the development of artificial intelligence. So you have the module could also be developed where you have a recalcitrant litigant openly defying the judge's authority or purposely testing the judge's exercise of judicial restraint, and to show how he can remain calm and professional in those types of environments. Harvard and Stanford, realize now they've done additional research that you could use avatars and virtual learning to affect attitudes and behavior. So you could have a virtual avatar go through a real life experience or a virtual experience to see what it means and what could happen. And you can become a member of a different race or a different gender and be subject to harassing comments, and then it might give you some insight and some empathy in terms of how people deal with those sorts of challenges. So let's go, I have just a couple more minutes. Let's do another question on poll, and I'll go back in and just activate this last question that we have. And how familiar are you with VR, virtual reality world? And only slightly aware, you're aware and you're investigating the use. You plan to use it within the next couple of years, or you're already using virtual reality for training. I mean, I think obviously this is a subject that not many people are familiar with, but I'm hoping that by this presentation today you'll be more aware of the opportunities that exist and start to explore those opportunities, because PhilJA clearly will be doing that and looking at it. So given the growing need to develop and adapt with modern educational techniques, the virtual environments and avatars should be explored as a viable teaching method to impart knowledge in a more engaging and efficient manner. And the modules, this is a sample of Second Life with the online platforms. And I mentioned the Stanford study about you can experience a different gender or race through your avatar and develop some conscientious feelings about what other people have gone through, looking at some of the technology and equipment that's available for the real world. I actually have an Oculus lens, and some of you have seen it. You go to any Samsung store, you go to any Apple store, they've got that available, and more people are taking advantage of it. The Philippine judiciary, I mean, you could have an avatar featuring the Chief Justice or Field Judge Chancellor Adolfo Escuna interacting with their students through the course. Many of you don't know, or those that do, you know, of course I'm Justice Torres, but when I go out at night in Makati, I use my avatar, which is Adolfo Escuna. Think about, you know, the goal. Tell me and I forget, teach me and I remember, involve me and I learn. I'm not sure if it was Confucius or Ben Franklin wasn't in there. But I'll leave you with this final thought from Oliver Wendell Holmes about wisdom being the abstract of the past, but beauty, the promise of the future. Thank you.
Thank you very much, Justice Torres. I knew it would be entertaining, it was. Our next presenter this morning is Ms. Lou Sao-Yun. Ms. Lou is the Chief Academic Affairs Department, Accounting for the Judiciary in Taiwan.
Good morning, ladies and gentlemen. That was a fascinating presentation. Although I was assigned in this session, but I'm not going to display any technology here. Instead, I'd rather to give you an introduction of our academy. So my topic for today is AJNJ's continuous innovation. AJNJ refers to Academy for the Judiciary, Ministry of Justice, Taiwan. So I'm gonna skip this one. So first of all, I'd like to introduce you how the judicial training system works in Taiwan. So the recruitment of the judges and the prosecutors in Taiwan actually included two channels. One is through the National Judicial Examination. The other is through the application by lawyers and professors. However, due to the heavy workload and the salary structures, the lawyer applicants or the professor applicants are very limited. So up to now, the National Judicial Examination still remains the main source of recruitment. This exam actually is a very competitive and demanding annual examination. Every year, there are more than 10,000 people participating in this examination, but the passing rate is only 1%. So I was told, I was asked these few days that how the difference between judges and prosecutors. So my answer is that in Taiwan, actually we pass the same examination and we receive the same training. So those who pass the National Judicial Examination must receive a 2-year mandatory training at our academy. So our training policy is the pre-job and long-term training, and also the co-training, which means that the future judges and future prosecutors are trained together by the same training provider. And the AJNJ, that is the institution that I work for, is a very training provider. I'm not sure if we are the oldest judicial education institution in the world, but the academy founded in 1955, which is older than a French institution. And it is an educational establishment under the Ministry of Justice and responsible for the pre-job training for judges and prosecutors in Taiwan. So this slide shows the whole training process of our judicial education. The training period is 2 years, which is conducted in 3 different stages. I'm going to skip this one because I promised that I will save time for honorable to let you participate in a very interesting game. Just brief introduction of this one. We have 3 stages. The first one is a 30-week-long on-campus learning. All the trainings are required to attend lectures at our academy. And the second stage that we emphasize is that students have to go to the prosecutor's office or the courthouses to receive a 60 weeks internship. And it is further divided into two parts. The first part is a 56 weeks long court or prosecutor's office internship, and the rest of it is an internship at administrative government agencies and relevant private agencies or other NGOs. And the last part is a 14 weeks finishing courses at our academy. In this stage, the trainees are further divided into prosecutors group or judges groups, which is based on their evaluation results or their choices. So after complete the whole 2-year training process, those who can be selected or assigned as a prosecutor or a judge. So now I'm going to move on our recent innovations at our academy. We went through reorganization by new legislation in 2013, which broadened our original training scope from the pre-job training to incorporate CPD programs, which is the continuing education. This program actually launched in 2014 with an aim to accept a lifelong learning needs for prosecutors and judges. This program actually is reviewed annually and with flexibility to be adjusted irregularly when necessary. We want to make sure that our programs can keep abreast of the updating legal issues and stay in tune with the society. For some program offers, actually we are further differentiated according to participants' seniority and their different roles in courthouses or the prosecutor's offices. The following are the features of our CPD programs. First, those programs normally are conducted in small-sized classroom or short-term training. These are our facilities in the academy. And we also emphasize interdisciplinary studies. And also we emphasize the on-site observation. This slide shows a recent seminar on food safety. You can see from the slide that we arranged visit to Taiwan's FDA war room so that the participant can interact and further exchange to the experts face to face. And these are the other programs. The first one is a workshop on medical practice. We arranged a visit to a renowned hospital, and we invite experienced specialists to have an in-depth discussion with the participants. The next one is a workshop on military cases. Actually, these workshop sessions are jointly conducted with our National Defense Department, so the participant can interact with the troops. The next one is a workshop on aviation safety. We invited the director and the experts from the Aviation Safety Council, and also we arranged a visit to the council's related facilities, such as the investigation lab, and also we arranged a visit to one of China Airlines base to let the judges and prosecutors can observe the emergency facilities in some operating divisions. Those are other CPD programs that we provided to develop participants the soft skills and their common knowledge. We provide foreign language courses such as German. We also have French, Japanese, and the legal English courses, and also the computer courses. And we also provide most update legal issues courses such as becomes transaction. This slide shows other available programs. So the courses under the red columns are the courses that are designed especially for particular groups such as head prosecutors or prosecutors in high court. And the courses under the green columns are courses that are related to new adopted laws such as government procurements or other courses like financial issues. And the last one, under the purple column, we have courses related to management or the leadership courses such as emotion management, price management, etc. So another innovation at the Academy is our e-learning system, which is not new actually. This e-learning system launched in 2015, which allows our in-service prosecutors and judges to learn on their computers, smartphones, and tablets from their offices. And this slide shows the map of Taiwan. Taiwan is not a very big country. It is about 36,000 square kilometers. The territory consists of Taiwan proper and other minor islands. So this e-learning system actually is meaningful to those who work in remote areas or other minor islands. This is our cloud classroom. This cloud classroom was created in support of our e-learning system with a capacity of only 56. However, when a course is taking place in this classroom, it can connect it to all the judges and prosecutors' electronic devices. So physical sessions taking place in the cloud classroom can be attended simultaneously and digitally by remote users. This cloud classroom actually is also used to record digital programs. Users can efficiently select the programs to watch during their available time. This is the website of the Academy's e-learning system. Up to July 2017, approximately 193 digital courses available on our website. Another innovation at our Academy is we adopted the paperless teaching mode and we established our digital database. So you can see from this slide, statistics shows that from 2012 to 2015, the printing fees of the judicial official classes actually accounts for the majority of our printing fee and paper cost. Therefore, in April 2015, we launched a paperless teaching mode, which turned handouts into e-books. So you can see from this slide, after the adoption of our paperless teaching mode, the left one actually is the previous that our students, their desks are occupied with papers, but now it's clean and
You have to pay excess baggage for that.
so actually this paperless teaching mode provide efficient learning process for all the participants in our academy. So every participant can build their own personal course material database, which is easier for them to read, to search, and to make notes on their digital files. So another innovation is that we established our own digital database of course material. Like I mentioned, our academy founded in 1955, so we have a lot of materials that is useful for our participants. So the past 6 decades paper course material at our academy has been scanned and stored electronically. The users are able to get more references outside their classroom. So these are the benefits that the adoption of a paperless teaching mode and our digital database of course materials. So for the last part of my presentation, a very short presentation, I'd like to share with you our international exchange. So the Academy actually has signed a lot of agreements with a lot of institutions, such as Waseda University in Japan, and also French National School of the Judiciary, and Sao Paulo School of Judges, the Prosecutor General's Office in Mongolia, and also the Judicial Academy in Vietnam. So under these agreements, the signing institutions can visit each other on a regular basis, and we can further conduct research on specific topics. So this just happened the last month. Since 2003, the Academy has helped to train senior prosecutors in Mongolia. So there has been long a discussion that the Academy provide the training courses directly in Mongolia. So just last month, in 2017, this year, September 27 to 29, we conducted our first overseas training program directly in Ulaanbaatar. And this is the first one, but I believe there will be many more in the foreseeable future.
What language was it conducted in?
Well, we have interpreter. Yeah, so we provide the courses in Mandarin, but we have a Mongolian interpreter. And it's free of charge, in case you want to know. So the last part, that's a prospect. I'm not going to read it, but I think as a judicial training providers, we believe that the judicial education serves as a continuous drive that prepares judicial officials closer to public expectation. Thank you.
Thank you very much, Ms. Lou, for that very interesting presentation. Our last speaker today is the Dean of the Singapore Judicial College in Singapore, Judicial Commissioner Foo Chi Hock, who we've had a lot of dealings with over recent years, and I think you'll find what he's got to say about gamification and its use as a learning tool very, very interesting.
Okay, thank you, Ernie, and thank you to all the other speakers. There were really serious negotiations about how much time each speaker is going to take. So let me start by asking you a question on gamification. If you have a beautiful scenery and you want someone else to share that scenery, what's the best way to do it?
Take a picture.
Sorry?
Take a picture.
Okay, I didn't think of that. No, I thought you should bring the guy there and say, okay, enjoy the scenery, right? like what our Philippine friends did for us yesterday, right? Right, so when you talk about technology, I'd rather just do a show and tell. I'll show you the stuff, right? And instead of trying to describe it in words, okay? I mean, never mind. All right, I'll show you the game itself. The risk, of course, in my doing so is that if it doesn't work, then that's the end of my presentation. So I'm putting myself on the line here. Wait, hold on. I want to engage you in another way, yeah? As you are going through the game, and we'll play the game together, right? I'll give you the basic rules, the basic information. We can all play the game together. As you are going through this, I want you to think about what went wrong in the implementation of the game. Okay, what went wrong, right? Even as you try and enjoy the game itself. Okay, next screen. Yeah, most of the time it's like that, but no passwords required. Okay, so this is the start screen, the landing page. It's a very common scenario. We give you a short blurb first, but I want to tell you the basic scenario here that we are talking about. Okay, I think we move on. So the rules, we give the basic information in terms of hypertext links. So these are the rules in the game world itself, yeah? We have some money, we are going to score you on the bank account. The lawyer will be presenting interim bills of costs, like real, right? Recovering costs, if you get costs from the court, payment of costs, and then you render a final bill. Hold on there, right? So I'll give you the basic scenario. It's about two international companies which are slugging it out in Singapore, right? Which is a very common scenario, very practical, because we are positioning ourselves as an international dispute resolution hub. So this is an example of cross-border litigation. the challenge when we tried to do and design this game is that we are trying to bring a real-life litigation setting and let the user experience it. So you tell me whether we have succeeded afterwards. Yeah? And this real-life litigation setting is not easily understood by novices. So when you have new registrars coming in, we put them through this game because it gives them something to have as background knowledge before they really see the real world. Yeah? So it's preparing them, at least mentally, for the shock of seeing real lawyers in action. The other aspect is that when you talk about a game like that, we are really dealing with civil procedure. To many novices, civil procedure is a very dry subject. Yeah? To those people in the courts, yeah, we are very passionate about it because that's what we work on. Right? You need to know the rules, like all the chess rules. But to many people outside of our world of registrars and judges, right, it's a very dry subject which is very difficult to master. Okay, so at the same time, the challenge that came across in trying to work out a game like that is that I was very adamant that we wouldn't come up with a Mickey Mouse game, yeah, which had very few learning points or learning points which are not evident, right? Because we have seen many software where at the end of the day, you could have just learned everything from that software. After spending 2 hours playing the game, trying to figure out the software, you could have just read an article for half an hour and you would have got the message. Yeah? So we didn't want a Mickey Mouse game. Okay? So the learning experience when you try and design a game has to be real and it has to be unique to the user so that it is different, right, from any other learning medium that the user has at his disposal. Okay, move on. So those are the rules of the game. These are the parties involved. So when you put the mouse over, you can get basic information about the two parties, Arcana, right, and Blackstone, right? Quickly absorb this. Absorb. I mean, that's what we expect our novice judges to do. Go back to Arcana. Okay, afterwards I'll give you a quiz. No, we won't do that. So basically, Arcana is the plaintiff, right? He's suing, this company is suing Blackstone, which is the defendant. Understand? Those of you who are not in litigation can follow, right? Now, A versus B, yeah, simple as that, right? A versus B. Arcana is in country A, no prizes for that, and Blackstone is in country B. Okay? The contract for the supply of fireworks was signed in Singapore, governed by Singapore law. Sometimes you wonder, right? You're in country A, country B, why do you sign a contract in Singapore? But that's what happens most of the time in cross-border litigation. We become a dispute resolution hub. Okay? So, the products were fireworks, they were delivered from A to B. Okay? And as happens in litigation, Blackstone refused to pay. No payment was forthcoming after the delivery of the fireworks from country Arcana in country A to Blackstone in country B. Right? Typical international trade situation. Okay, in the meantime, you have Blackstone transferring all its assets to Singapore. Okay? Blackstone transfers all the assets to Singapore. Now this is interesting because the first thing that a litigation lawyer wants to do is to what? Seize those assets, right? Mareva injunction, or what is known in England as a search and seizure order, right? Mareva injunction. One last point about the background is that the plaintiff, Arcana, prefers to continue the proceedings in Singapore, right? Although they also commence proceedings in their own country, country A. Right? Where do you think Blackstone wants the proceedings to take place? In country B, their own country, right? Hello? Have I lost you? Right, so there are three dispute resolution venues that this litigation can take place in. Right, so now, Blackstone's assets are all in Singapore. As a Singapore lawyer, what is it you want to do? Right? You get a Mareva injunction. Okay? Note right at the top, you start off with a bank account of $100,000. That's quite interesting, right? Because most of the time people forget to get the money from their clients. Or do they? The moment you sign the warrant to act, right, put in $100,000 in my bank account because I'm using up money for you. And you start off with a score of 0. You do correct things, right, you'll get the score bumped up. So, in this case, what do you think is the answer? Any litigation lawyer? To get a Mariva injunction, you need a cause of action. Case in point, Siskina. You all have heard of that, right? Okay, so anyway, never mind the details, right? So you get the idea. It's a multiple choice question, very simple. You choose the whichever is the path you want to take. So if you are advising Arcana in Singapore, that means you're an international lawyer. Wow, great, right? You tell your client, all right, I advise you apply for a standing Mariva injunction, get all the assets. You don't even have to file a writ. Okay, go for that. Sorry, incorrect. Right? When you make an incorrect application, you get costs ordered against your client, right? Your bank account will go down, but you haven't quite figured that out, right? So this is where it happens. It's incorrect because you need a cause of action. So option B is the correct answer. So it gives you a chance to try again, right? There are certain options where it goes for a sudden death. Yeah, so if you can't figure out the form of a writ, you go for sudden death, the guy the program will ask you to go back to law school, come back in 4 years' time. Okay? Right, so now we are back to this. So it gives you a chance to retrace your steps. Yeah, you get the wrong answer. Alright, what's the next answer? Okay, we try for B. Boom, correct. Right? So when you do multimedia authoring, right, one important point to realize always is that feedback must be immediate. You cannot go through 10 screens after that and tell them the correct answer is this. The user would have forgotten. Right? The feedback must be immediate. If it's wrong, forever I'll know, okay, I'll never click that button again. But the good thing out of it is that you gain knowledge. Right? You know that that's the wrong answer. Right? So now you know that's the right answer. You need to have a course of action. Therefore, you must file your writ first in Singapore, right, and maintain the Mariva injunction. So your score now, you have spent $3,000 so far. Right? So at the end of the day, when you compare with different participants, some people, and this becomes a real life dynamic, some lawyers actually don't spend money for their clients at all, right? But in the end, they still lose the case. Or do you want a lawyer who spends a lot of your money, but at the end of the day, you win your case? Right? So these are real choices that you make, and your choices here determine what kind of lawyer you are. Right? Of course, there's a third category where you spend all of your client's money and you lose your case. Okay, very good. So you look at the score, you have made one right choice, 20 points for you, bank account goes down a bit. We go on to the next scenario. Right, so this is a scenario where we give the user some chance to give us feedback. Right, not in terms of the fixed choices that the program gives you, but your own words. Okay? So we ask you some questions, and we also use this to assess whether the user needs additional instruction or remedial training. Yeah? From some of the answers, the guy may have got all the multiple choice questions right, but from his real words, you realize the guy actually doesn't understand anything. Okay, so that gives you a chance to come back for counseling. Yeah, the word is counseling. Okay, so let's go at clue 1. So we give you some clues to help you. So this is just a case. We summarize the case for the user, right? So at least the key cases that are important to the work of the registrar, they have it at the top of their heads, right? So go backwards now. I close this clue, go to the next clue. Right, so there's another case that we give them. So these are the two most important cases in this scenario, right? That we expect the registrar, right, or the lawyer who is advising, you need to know your stuff. Okay, and you must carry these cases in your head if necessary. Alright, so we go on to the next. So there's one, read the full case, right? So we also make available the actual documents, right, in the case as well as the case reports hyperlinked to this particular software, so that you can stop anytime you read the whole thing. Yeah, I mean, it becomes a reading exercise, and I make no apologies for that. Right? There are times you need to look at the actual documents. Okay? I mean, I know that one tenet of multimedia sort of e-learning software is that you have to summarize everything for the user. Yes, right? I agree with that. You make things simple for the user, yes, but there are some things that cannot be made simpler. In which case I say, you must look at the actual documents. You see, when I first trained as a registrar, I realized that one of the impediments to my learning was that I had actually not seen an actual writ. Right? They are talking about striking out irregularities in a writ, this must be there, but until you see the actual writ, it doesn't make sense to you. And that's also one way of teaching civil procedure. You look at the actual documents and you figure them out yourselves. After that, the rules will come alive when you apply them. Okay, so we move on. Close the blue page and we move on to submit. Yeah. Taken as done. Okay, so now, second part now. Right, you've got the Mareva injunction, you need to serve the writ. Right? Remember that Blackstone is in country B. Right? Blackstone is not in Singapore. So you need an order for service out of jurisdiction or an order for substituted service. Anyone wants to hazard a guess? Okay, now I go straight to the correct answer. Right? So you apply for service outside jurisdiction, blah blah blah. Okay, the dates are important, but if you don't need to know Singapore law, it's not so critical that you understand that. I'll explain to you. Okay, look at the bank account now. He spends $4,000 so far. Right? Actually, in real life, it's more, but we're just trying to make it economical. Okay, the score: 2 good choices, 40 points. All right, go next. So now we have another situation. You see, in Singapore, when you serve a writ, right, the guy must enter appearance. Otherwise, you're entitled to a judgment in default of appearance, and that ends the whole litigation. Right? So, being an international lawyer, very sensitive to that, because if the guy doesn't enter appearance, you go for default judgment. So, we go for the correct answer, default judgment. Right? Don't worry about the timing. I mean, there are certain rules, like 8 days after service of the writ, you must enter appearance, things like that. Yeah. So you count, you got the correct answer, you move on. So after getting the default judgment, most of the time, right, the defendant will not even know about it because it's probably not served with the writ. So when judgment is entered against the defendant, they won't know until you tell them, look here, I've got judgment against you in the court of Singapore. Then they will wake up and they want to apply to set aside the default judgment. Okay, it's the usual thing. So in doing that, they're also trying to get the lawyer or whoever is the user here to get to understand the sequence. So there are various sequences that are almost standard, but there are certain sequences that will depend on the decisions you make. Okay? Move on. Okay, so before we move on to the next scenario, we then give them a test. Right? Like I said, we want to know what exactly the user understands. Okay? Okay, move on. We can move on. So the bank account has gone down, but we give them one of the key cases, the Court of Appeal decision that you must know. Right? So we literally put it in their faces. So at the end of this program, you cannot tell me, oh, I've never heard of the case of Mercury. That means you have not gone through this whole program. Okay, so we put it in their, right in front of their faces, you got to know this case. We force them to read it before they can move on. Right, thanks. Okay, so now Blackstone takes a tactical step, right? Instead of filing a claim in country B, they come back to Singapore now to fight on foreign soil. Okay, so of course part of the reason was that the proceedings in country B are tediously long. Okay, so move on. Right, more questions. So what should you do? Right? These are all tactical steps. I think we can just move on. Never mind. One the right, yeah. Right, you contest the application on forum non-convenience. Those of you who are litigation lawyers will understand. Once you have different countries involved, you choose the venue, right, of your litigation, which is the most appropriate for your dispute. Okay, the most number of connecting factors to your jurisdiction. Right? So apparently in Singapore, contract signed here, the piece of litigation is governed by Singapore law, so it should remain in Singapore as the foreign convenience. Yeah? So you realize this, Blackstone order to pay costs of $500. So when you win a case, you get costs, it goes into your bank account. So a bank account is accordingly credited. Yes? So.
I really like the idea of the open-ended question, which then the participant has to answer.
Do you have staff who is monitoring
anyone taking these courses so that within a certain amount of time, they are grading those answers and
Yeah.
replying to them?
Yeah. So we haven't deployed this system-wide, yeah, because when we finished this, we deployed it and then we fell into disuse. We were trying out some other things, but ideally, this should be linked to what is called an LMS, a learning management system, where all the candidates, the participants are then monitored, literally, how much time they are given to complete it, and learning management system, LMS, will allow you to do all those administrative tasks. Yeah. So the idea is when we have text fields, those fields are pulled out for the instructor to assess the participant later on. Okay? So look at your score in your bank account. Yeah. So long as it doesn't dip to zero, you are quite safe. Yeah. Okay. Next. I just run through this part. I think it's getting boring. So there are certain other procedures. We move on to other scenarios next. Okay, so there's something called summary judgment, right? And it's dependent on when the defense is filed. So it has to do with different timelines. So option B is the time for summary judgment. Okay. Right? So you file your application for summary judgment at different times against the company, against the CEO. Right? So one is a corporate defendant, one is an individual defendant. Okay? You are ordered to pay costs. So when you have to pay costs to the other party because you lose your applications, right? What happens? Your bank account gets debited, right? So that is the life of a litigation lawyer. And we want the registrars to appreciate that when they make orders for costs, it has real consequences to the parties, to the lawyers involved. Sometimes you lose your client when you keep paying costs to the other side, right? Which is why civil procedure is so interesting to me, at least. It's almost like a chess game, right? And there are times when you really checkmate the other side without a trial, right? And that's the purpose of summary judgment. Okay, move on. Okay, and then there's something called security for cause, which is another form of interlocutory application. Some lawyers file these applications to put for strategic reasons, right? Not because they want the security, but because they know that the other side cannot afford the piece of litigation in the long run. Therefore, if I keep pressing you and you can't comply with orders of course, there may be no trial. Right? So it's very much like a chess game. Okay? What? Right, so further arguments, I won't bore you with the arguments, move on. But you see that the scenarios are changing, yeah? This is about the Riddick principle, that when you get a document for discovery, you can only use it for the purposes of that piece of litigation. Yeah, the Riddick principle, common law lawyers will know about it. Now I move on. Right, correct? So court grants your application, note the score 140, bank account is depleting, go down. Right? Just prior to trial, parties settle. Right? So that's the end of it, right? Parties have settled. You just send your client a bill of $20,000 for your efforts. In real life, of course, like 5 or 10 times more. Otherwise, lawyers cannot buy the BMWs. Okay, next. Okay, now, summary, right? Thank you for participating in this game, right? We will record all these things, highest possible score, 140, right? And although we spent quite a lot of money, but in the end, client is quite happy. Okay, now watch this. Go. So this is the part where I think is quite revolutionary. I was quite pleased with the whole team when we came up with this because I've never seen it anywhere else. Yeah, so you see the ideal path is where you get 140 points, the ideal score, right? You will be compared with your actual path, right? In this case, ideal path is almost like actual path, right? Because you have 140 points, right? But you will see where you went wrong, okay? When the ideal path is juxtaposed with the actual path you took, you will see where your choices are less than ideal, right? Less than ideal. And that's where the real learning takes place. That, okay, I should have actually made that choice. So you go backwards, you play the game 2 more times, you will get all the knowledge that the game wants you to get. Good? Good? Very good. Right. So that's basically the game. Let me run through other parts very quickly. I have to ask for more time. Okay, so why do you use games for learning purposes? Why do you use games? Someone hurry up, he's asking me to stop. Why do you use games? Because they are, sorry? Because they're fun, right? No, don't look at the slide, yeah? Why do you use games? Because they are fun, right? Secondly?
Keep your interest.
Sorry?
Keep your interest.
Okay, why do you keep your interest? Because you want to win. Right? Games allow you to win. Yeah. But of course, be careful when you make a game. It must allow the user to win sometime. It cannot be all the time the user loses. Right? It's like when I played chess with my daughter and I beat her, and after that she refuses to play chess with me again. Learn that. Learn that. It's a lesson in life, right? So games must be dramatic in the sense that even though you are trailing, you have the chance to win. Yeah? That's when you want to continue playing the game. Right? So gamification has got some principles on designing games. Of course, games bring out a competitive spirit. Yeah? In the write-up to this, we mentioned that the user can grade himself by himself. There is no ranking as in the other portals. That's what we meant. It was not so clearly expressed there. What we meant is that the user is not pitted against someone else. So at every choice he makes, he feels that, wow, I'm trailing. That's bad. Right? But depending on the purpose you want to achieve, sometimes you need to do that. But the other online portals do have that ranking table where it's competitive. Yeah? So I wanted this game to be learning at your own pace so that it's more collaborative. But another way of using the Silver Pro game is to get 3 people to play as a team. Right? So there are various ways to skin the cat, as it were. Okay, and in that game, you also cycle through all of Cobb's learning cycle, right? Those of you who have gone through the pedagogy class, you'll realize I'm trying to apply what I learned from the 2 American instructors yesterday. Okay, I want to just finish off because I'm overstaying my welcome. Sorry, I can't get your feedback on what is the minuses in that game. Any ideas? The minuses in the game? What could have been done better?
I can see minus.
Yes?
Thank you. I can see a minus, which is although it works really well in an impersonal commercial dispute.
Yes.
I'm not sure how well that would work in a crime or family scenario, which it might trivialise the concerns of the parties by trying to convert it into a game scenario.
Yeah. Well, that is why this game is so serious. Right. I see no problems converting this to family or to crime because I actually thought that the whole manner of the game progressing is rather too serious for an online multimedia game. So I don't see a problem with that. Make it serious, right? In fact, one of the drawbacks I see in the game is that I could have added VR, virtual reality. The player has to wear Oculus and it adds to the excitement. Yeah, I could have added a lot more things, more bells and whistles, music, right? A voiceover. Actually, one of the chief drawbacks in this game, and every time I ask for feedback, people have told me that, right? The chief drawback is that the words are too long, the narratives are too long, too much reading. I accept that, right? But it's a trade-off that I had to make. Okay, I end by telling you that in my slide, right, there are various sources. You can go to an online portal called Kahoot, right, which is great for creating multimedia quizzes. Just go straight to Kahoot. Right, so you can have quizzes online, and the software is free and is really idiot-proof for creating your quizzes, right? Another software is Quiz, Q-U-I-Z-Z. It's not here. Okay. Quiz, Q-U-I-Z-Z. We also use Survey Monkey. Yes. Right, so the sources are all there, the references are there. You look up the sources, learn how to use it. SurveyMonkey is very much like the poll app that CJ Torres demonstrated with you guys, so I will stop. I will not go there. So I just want to end by hoping that some learning points have been brought forward, right? And most importantly, that you'll be inspired to take some action when you go back. Thank you very much.
Thank you very much, Commissioner Hopp. Most interesting. I know you would have liked another 10 or 15 minutes, but all the speakers have been very good in keeping to their times. We've still got time for a few questions. Can I ask you, if you do have a question, to identify yourself and the office or organisation from where you come, and if you have any handwritten questions, and we've only got a short time, provide those to the members of the Secretariat. Thank you. Questions?
I'm Shahid Shafiq from Sindh Judicial Academy, Pakistan. The presentations of all three presenters were good, and we do hope that we will be using your system, and you will be cooperating to share with us to set up this similar system in our jurisdiction. Where I am addressing to the Singapore. Sir, your game was quite interesting, but you used two terminologies. One is correct and other is incorrect. And if I am opting and using that game and my all answers are incorrect, disappointing me and making a question that I am not so competent and I am not following the speakers. So these two words perhaps need to be changed in your game. There is a possibility that at our judicial system, we are not working in a scientific manner. This is social sciences. Today's right may be declared tomorrow wrong. So the ideology which you are trying to impose on the learner is that this is right and this is wrong. Either you fall in right column or wrong column. So I would suggest that please give some space to the newcomers so that his new ideas may come in place, and senior should not so compel to junior to help to apply his ideology. So, and perhaps this would be the independence of judiciary as well. Instead of imposing certain ideology, we need to. And secondly, when in particular situation, you were discussing a particular law. There is a principle of choice of law. Perhaps there is a difficult that one agreement is executed at place 1 and cause of action, it is not necessary that the cause of action will also be occurring in the same place. This may occur at place C or D where it was executed. So there may be a issue of interpretation or understanding. So according to your understanding, the Singapore court has the jurisdiction, according to my understanding, where the execution of agreement was to be executed and it was refused. That was the place of understanding. So perhaps we need to give some space, and those two words are very strong desire to be. Thank you.
Thank you. I think that was more a comment than a question.
I feel obliged to respond to that. I accept your point, absolutely. Yeah, but I just want you to consider on the other side of the line, right? This idea that you must sometimes distinguish between the independence of the judiciary and the incorrectness of the judiciary. Because there are times, especially to a novice judge, right? You are actually obliged to tell him, look here, that answer is wrong. Okay, because if I don't say that as his senior, right, he's going to get allowed on appeal, right? It will be more traumatic for the guy. But, like I said, I accept your point. One way we can make this game even more challenging, and it means more money and more time and more thinking on it, to make the analysis rigorous, is to have options that are less than ideal. So, certain options that you choose, let's say option A, you get maybe 20 points. Option B, you get 10 points. Option C, you get 5 points. So, by the gradation of the score, you know that, well, I'm not completely wrong, right? But I'm not completely right either.
Thank you. Next question.
I just wonder if a lawyer or law firm got sued for legal malpractice or negligence, do they want to use the results of that game against you in court?
I hope they don't.
Okay, further questions? Any hands up? Okay, well, I better stick to my time setting as I asked the presenters to. But what you've heard this morning is the future. It's something that my own commission has been working on for the last at least 3 years, and we use gaming technology as a teaching tool quite extensively. I'd like to thank each of the speakers for the work that they've put into their presentations and the way that they were presented this morning has been terrific. Thank you very much.
Just as a point, I gave the secretariat, I wrote a short paper for this session, it's maybe 5 or 6, but it has some authorities in it that you can look and go to, and as well, you know, they have the PowerPoint presentation there as well.
Thank you, Justice Torres. Well, that concludes the session. Lunch will be served outside, and we start again at 1:30.